On this morning's Ag Issues program, a pleasure as always to bring on to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine. Good to be with you.
Well, let's get to it. And this is one of several decisions that are pending in the Supreme Court, U.S. Supreme Court, concerning agriculture. And this one from Thursday concerns California's Proposition 12. I guess for those who may not be familiar with that, and then just talk about that, but also your thoughts on what came down from the U.S. Supreme Court on Thursday.
Yeah, just for those that may not be familiar with what we're talking about, it was back in the election of the fall of 2018 that California voters voted on Proposition 12 and decided by over a 60% majority out there to ban pork meat that comes from breeding pigs that are confined in what they deem to be a cruel manner. And what they think is a cruel manner would be sow crates that they think are too small, where the sow can't stand up, turn around without touching the sides. And, of course, here in this part of the world where hogs are actually raised, California doesn't hardly have any hog farms. We know there's a good reason for doing that, health, sanitation, don't want the sows to crush the piglets, those types of things. But anyway, they passed that law and said, you can't have access to our market. And by the way, we consume about 13% of all pork products in the nation, even though we don't raise any. You don't get access to our market unless you conform to the way we want those hogs to be raised. Well, you had two pork producer organizations, including NPPC, that challenged the law as unconstitutionally interfering with the preferred way that the pork industry does business. And they claimed that violated something known as the Dormant Commerce Clause. And, of course, the Congress, under Article 1, Section 8 of the Constitution, has the power to regulate commerce amongst the states and can preempt state laws that are discriminatory against other states. But when Congress is silent, then there's this judicially created theory known as the Dormant Commerce Clause. It's where Congress hasn't acted, and so Congress now, or the courts, can take a look at a state law that impermissibly discriminates against out-of-state conduct. And that's what they were arguing, that the court should do in this instance. And there had been, by the way, various bills that had been introduced in the House, all by an Iowa congressman going back to 2015, to address this conduct that states might be doing, in anticipation that a state like California would do this. And by the way, I may come back to it later, Michigan has a comparable piece of legislation that hasn't received, or a law in Michigan that hasn't received nearly as much attention, but that plays into the politics of all of this. And we'll see that hopefully in a little bit. But this bill was introduced in the Congress numerous times. It never got out of committee on a couple of occasions, and another time it passed the House version of the Farm Bill, but the Senate cut it out because you didn't get the support of the Iowa senators. Of all people to not support it, Senators Grassley and Ernst didn't support it going into the Farm Bill. And so we end up with this court case, and then now a negative court opinion as far as the pork industry is concerned.
Yeah, and it was a 5-4 decision, by the way, in the court, and you always see or hear about, I guess in this case, the written opinions that come out, and in this case, for those in the plurality of those who voted to uphold the lawsuit and uphold Proposition 12, Neil Gorsuch wrote the primary opinion.
Yeah, he did. It's quite the interesting mix of justices. I mean, I don't think I've ever seen a court case with the political philosophies and judicial philosophies of the court mixed up like this. You had on the plurality opinion, Gorsuch, Thomas. Okay, we can get that. But then Sotomayor, Kagan, and Barrett. Those were the five. Now, Greg, I don't think you're going to see you may never see another opinion with those five all together. And then you had another opinion by Sotomayor and Kagan, another one by Barrett by herself, and Kavanaugh by himself in a partial dissent, and then Roberts writing a partial dissent with Alito, Kavanaugh, and Jackson. So you have Roberts and Jackson on one side. You have Thomas, Sotomayor, and Kagan on the other side. It is quite the mix of opinions. And as you know, I've been writing on this for some time, and I said, you're never going to get Gorsuch and Thomas. That we know, and you're probably not going to get Barrett. So I had those three pegged that there's no way, because they don't even believe that the Dormant Commerce Clause exists. And Barrett wrote a separate opinion to basically say that. No, we can't weigh, we can't balance the out-of-state impact with the in-state benefit. We just can't do it, which is what Dormant Commerce Clause is all about. And for the lawyers out there that are listening, we call that Pike balancing. Well, the historic Pike balancing test came within 2 votes from no longer even existing in this case. So I had those three pegs that, nope, you're not going to get any of those. And you didn't. But then what was interesting is the other justices that joined in on that. And Kagan and Sotomayor were saying, and this was an interesting part of the opinion, and Kavanaugh really points this out too. They said, well, you know, plaintiffs, pork producers, attorneys, you really didn't emphasize the fact that we need to do some balancing here. You went for what's known as extraterritorial effect. Well, that's a strategic mistake, and they were told that was a strategic mistake in the Ninth Circuit. That's just completely wrong to argue the case that way, complete bad tactics, and to argue impermissible extraterritorial effect of the law, because the courts have been pretty consistent in saying, well, you only argue that if you've got a law that's regulating prices in other states, and therefore then it's per se unconstitutional. And the court made a lot of hay out of that. They said, well, look, you're basically arguing this is per se unconstitutional, but it's not a price regulation statute, so we can't really look at extraterritorial effect. But that was the pork producer's primary argument. Instead of focusing on, well, there's an effect out of state, there's a benefit in state, you need to balance these to see if that violates the Dormant Commerce Clause. And what Sotomayor and Kagan were saying was, yeah, you really needed to emphasize that. You didn't, since you focused on this other argument. You can't get past go. And this case was teed up on a motion to dismiss, and the court never even got to the merits. They said, you didn't bring a case that we can hear. We got some, it's a lengthy opinion, and there are 5 opinions, so there's things that we can take from it all over the board. But on the procedural issue, they couldn't even get off the starting line.
Having said all that, and things that you heard throughout all this, isn't this case a states' right issue?
Well, I think in the strictest sense you could probably say that, Greg. But here, the state legislation impacts virtually zero hog production in California, because there really isn't any hog production in California. And the burden of the law is entirely outside the state of California and impacts practically the entire hog industry in the United States. The hog industry in the last 50 to 60 years, has become very highly integrated, and it's comparable to a manufacturing process. So those people that are impacted by this can't vote out those that created the law. So there's no Iowa hog farmer, there's no hog farmer in Kansas or Nebraska or anywhere else, or North Carolina, that can vote on this Proposition 12, which impacts them. And so that's kind of like taxation without representation. And Justice Kavanaugh, in his separate opinion, his partial dissent, gets at this point. He said, quote, California's approach undermines federalism and the authority of individual states by forcing individuals and businesses in one state to conduct their farming, manufacturing, and production practices in a manner required by the laws of a different state, end quote. And then he brought this out in oral argument, but he expressed this concern in his opinion that other states would retaliate doing this stuff. And I had mentioned last fall, and I believe it was Justice Alito in oral argument in response to a question, but Kavanaugh focuses on this, saying, what's to prevent the state of Iowa, for example, and I was on the phone with an Iowa senator last week, and the idea was, well, can we call a special session right now and pass a law comparable to what California did, but saying that if you want to sell almonds in the state of Iowa, you have to certify that they're hand-picked. We don't want you damaging trees by shaking the trees to harvest the almonds. They say, well, sure, you can do that. Now the court says you can do that. So it's this kind of gamesmanship that this leads to potentially, and Justice Kavanaugh was getting at that point in his opinion. And he also mentioned that the import-export clause might be implicated, as well as the privileges and immunities clause, the full faith and credit clause of the Constitution. Now, I think he's wrong on full faith and credit for other reasons, but he's throwing out other possible avenues that this could be attacked. And, the concluding comment by Kavanaugh, in his opinion, was really a smackdown of the pork producers' attorneys. Here's a quote from Kavanaugh. He says, "It appears, therefore, that properly pled dormant commerce clause challenges under Pike," that's the balancing case, "to laws like California's Proposition 12, or even to Proposition 12 itself, could succeed in the future or at least survive past the motion to dismiss stage," end quote. That's an incredible statement. I told my law students, which were in their last week of exams last week, I said, you don't ever want a judge, let alone a U.S. Supreme Court justice, to say anything like that about what you have done. He said here, if you learn how to properly plead a Commerce Clause case, we might actually hear it. Ooh, that's brutal.
That is, most definitely. Now, having said all this and knowing what the Supreme Court decision is, I think we obviously know, but from your perspective, what are the implications we could see?
Well, it's certainly going to cost billions of dollars for the industry to comply, and those costs are going to get passed on to consumers of pork. And lower wages in the industry, reduced benefits or layoffs to workers on hog farms and in packing plants. And you want to think of who those workers are. Those are the ones that can least afford to take the hit here. But that's the economic, practical implication of what's going to happen with this decision. It'll put smaller hog producers out of business that just simply cannot comply with this. Others, as was indicated in a footnote in the opinion, might actually benefit from it. There are niche hog producers out there that produce hogs in this manner, and they become good at it. Now, it's a small niche part of the market, but they'll be fine. But the vast majority of hog production does not comply with this. And of course, the option is, all right, we just don't sell into California. But again, that is a very large market. That's 13% of the national market. So do you do that and find other uses, other places to sell those products? California consumers also would be hurt in this, and any consumer of pork because of prices that would go up as a result of this. So it really kicks it back to Congress, and the court said that numerous times. Well, Congress has tried. They haven't done anything. Congress can clearly legislate in this area if they would do it, but the politics have never been there. You've tried to stick it in a farm bill, and Pat Roberts actually took this from the House side. He took it to Debbie Stabenow, and there it hit a wall because Michigan has a similar statute. She's not going to let it go anywhere. And as I said earlier, Grassley and Ernst in Iowa wouldn't keep it in the farm bill. And then you're going to lose the California votes. They didn't support it on the House side. You lose the Michigan votes on the House side. So it's very difficult to get this through. Now, I would point out that Senator Marshall here in Kansas has grabbed this. He's changed the name of it, and he's introduced it into the Senate again. So it's not dead. It's just very difficult politically to get it through. But that clearly is what the court is saying. This is a matter for the Congress to deal with.
Which this could potentially later down the road, if nothing's done, potentially could hit within the beef and or, say, poultry industry or any livestock type of industry?
Probably more likely with respect to poultry because it's much more highly integrated than beef is. But you'll have the animal activists, which is where this got started, Humane Society, other types of animal activist groups out there pushing this. You can be rest assured they're not going to stop. So it'll go industry by industry. And indeed, the California law also picks up and applies different parts of that bill, Proposition 12, to poultry and other products too. But the case that got to the Supreme Court involved pork.
Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, is our guest on the program this morning. And, of course, the bulk of what we would talk about is on Proposition 12, but other things to talk about, Roger. This is legislation, reintroducing legislation known as the Food Date Labeling Act by a bipartisan group of federal legislators.
Yeah, this was introduced in late April in the Congress, and it's a labeling bill that says, well, we want to get rid of all these confusing labels on food products, and we want to go with one. So it would be standardized language to communicate expiration dates. And so we would get rid of a lot of what is deemed to be, I guess, confusing labels, and use a best if used by label, which would indicate the date when food quality starts to deteriorate, and then used by date would indicate the food shouldn't be used after that date. California has, we're back to California again, California has similar food labeling bills before it right now, too.
Also, one other thing I know that you have written on this specific topic numerous times, and this is administrative agency deference.
Yeah, and there's actually just a few days ago, the U.S. Supreme Court decided that they would hear a case on this particular issue. We call this Chevron deference, and this is how the courts view administrative agency decisions. And they just review that to see if the agency acted in a reasonable manner in construing the underlying statute, which is probably vague or an area of the law where Congress hasn't even spoken on. And so the agencies have come up with a rule. And unless that's arbitrary and capricious, then under Chevron deference, the agency wins. And so this is a big issue for farmers that get into administrative disputes with USDA or branches of the USDA or EPA or Corps of Engineers or out west, whether it's the Bureau of Land Management or the Energy Department or whatever it is. Those agencies almost always win. Well, the court is going to take a look at that deference issue. That's a big deal.
You've got an update on specific WOTUS update, not from the Supreme Court, obviously. This is the state of Kentucky is starting to get involved.
Yeah, we're still waiting on the Sackett opinion. That's going to be the next major U.S. Supreme Court opinion to drop that involves agriculture. But we've got another federal circuit court, the U.S. Court of Appeals for the Sixth Circuit, has enjoined the 2023 WOTUS rule, the EPA Corps of Engineers WOTUS rule. And I think we're up to 27, 28 states now that have actually enjoined that. And we're still waiting on the Sackett opinion, which is not specifically a WOTUS case, but I think all of us are anticipating that it's going to have major implications on this rule that the Biden administration put in place earlier this year.
And finally, a very interesting case out of Colorado with their state Supreme Court concerning their state engineer and looking at water rights in the state.
Yeah, this is a feedlot in Eaton, Colorado, and that's in the northeast part of Wyoming, just about a half hour south of Cheyenne. And you got some of the biggest names in the cattle business out there, and people will recognize one of them, Monfort. They run a feedlot out there, but they had a water right from the state that said you can draw water out of a nearby stream to irrigate your crops. Well, they had been using it for the feedlot, so it's an impermissible use of their water right. They'd been doing that for years. The state caught them in 2016, and this case involved the powers of the state engineer of water resources, and the court said, yeah, that state engineer has got a lot of power, and they can make you comply with what their plan is now that they're imposing on you, and you're going to have to pay all attorney's fees and all court costs. So feedlot lost that one, but the point of that is if you got a water right, make sure you use your water right according to what it says. Don't use it for an impermissible use. If you get caught with that, you're going to get in big trouble.
And Roger, as always, they can find more information on anything that we talked about on your blog as well.
That's true. Yeah, washburnlaw.edu/WALTR. A lot of these I send over to K-State, so it's also on the Ag Manager website.
All right, sounds good. Roger, as always, much appreciated. Thank you very much.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us this morning on the Ag Issues program here on 580 WIBW.